Hi, I'm Darren Cope, owner of Cope & Co, specialist letting agent based in Derby. Now, again, I'm here to talk about the Renters' Rights Bill and the reforms and changes that it's going to bring in, which is going to result in a dramatic shift in the private rental sector for both landlords and agents. Now, this is video number 9 in my series, in which I look at the different aspects of the bill, what it means for landlords, what we can do as an agent to help landlords negotiate these changes. So I've left the worst to the end. So in this video, I'm going to look at how the powers that be intend to enforce the new legislation. Now, the bill overall signifies a shift towards empowering local authorities with greater enforcement powers, reducing the reliance on the courts for addressing many of the disputes that arise, and many of the disputes that have arisen in the past will be or would have been dealt with by the courts. That's going to shift across to the local authorities. Local councils will have expanded authority to directly investigate complaints, conduct inspections and issue penalties for breaches of the legislation. Now, the decentralisation aims to streamline the enforcement process and make it more accessible and efficient for tenants. Now, the change of emphasis on enforcement is designed to tackle issues such as substandard housing, rent violations, illegal convictions, and pretty much anything else that the bill is going to throw out. Under the bill, local councils are granted additional resources and authority to actively investigate complaints, conduct unannounced inspections, move on to that in a minute, and monitor compliance, safety regulations, rental pricing rules, tenancy protections. Now, with these expanded powers, councils can impose substantial fines and penalties on landlords and agents who fail to meet their obligations. Initial failure to comply will incur a penalty of up to £7,000, and more serious, persistent or repeated non-compliance penalties of £40,000, with potential criminal prosecution as well if it obviously gets really bad. Harsh consequences, including prohibiting landlords from letting out properties altogether. You know, it's pretty serious stuff. This is a big one for me. The authorities will have the authority to retain the revenue generated from fines and penalties that they impose. It's not necessarily been the same in the past. It's all been in a centralised government fund, which is then distributed across various councils across the country. With that changing, the provision is designed to bolster enforcement efforts by enabling councils to reinvest these funds into further regulatory activities. Now, if you missed it, I did say that the local authorities will have enhanced powers to conduct unannounced inspections of both properties and letting agent offices. This is a massive shift towards more proactive enforcement and moves away from the reliance on tenants complaining as the primary triggers for these type of inspections. The legislation does outline strict guidance and thresholds for when unannounced inspections are justified, and fortunately, these powers won't extend to the private, non-rented portions of a landlord's personal home unless there's a very, very, very clear legal justification to do so. Now, I've banged on about rent repayment orders in a few of the previous videos, so I want to just explain what that is. Now, a rent repayment order, or RRO, as it's obviously going to be called, It's a legal mechanism that allows tenants or local authorities to claim back a specific amount of rent from a landlord who has breached specific legal obligations. So if the previously mentioned first tier tribunal receives a report of a listed offence and it is satisfied beyond reasonable doubt that the landlord has committed the offence, it can order the landlord to repay an amount of rent. So under the bill, the maximum amount of rent a landlord can be ordered to pay is going to double from 12 months at the moment to 24 months. That's 2 years worth of whatever rent the property was bringing in, which will no doubt be appealing for tenants and local authorities to pursue. That's the reasoning. As important, the bill will also extend the period in which an application for a rent repayment order after the offence has been committed is going to be extended from 12 to 24 months. Essentially, it's preventing these being timed out. So 2 years, up to 2 years after the offence, it can still be bought as a report. So I know when I explain all the potential fines and penalties like this, I know it sounds very scary. However, the bottom line here is compliance. It always has been, and it is even more so, especially with the shift in enforcement to the local authorities. Stay compliant with the regulations, and the local authorities won't be using any of your cash to boost their already depleted coffers. We're here to help, we're here to advise, we're here to guide, we're here to inform, and we're here to help you stay compliant. If you want to contact us on any aspect of the bill, get in touch. If you want to contact us on any aspect of letting your property, get in touch. If you want to transfer a portfolio of properties from one agent to us, please get in touch. It's really important that you understand what's coming. We can help. We've created a new service for landlords in a direct response to the Renters' Rights Bill by bundling all our lettings and property management services under one simple monthly payment. It's called Let Simple. It's called Let Simple for a reason, because it's easier than any other service you've seen before. One monthly repayment covers everything. If you want to watch more about that service, then there will be a video which you can access from the same page as you've accessed this video, and all the videos that we've done in this particular series can be accessed at rentersrightsbill.com. Thanks for watching. Get in touch. I hope you found the information useful.